My lords, may I be permitted to mention a matter? This matter was mentioned by Mr. Paritosan on Friday for an application to be listed. We are not some constant to move this application already.
Let us see, we'll see to it. Only motions, give only motions and applications.
Kindly, my lord, to mention one matter. Your lordship will refer to one matter, my lord, that for transfer of the suit, my lord, to NCLT. In that matter, my lord, your lordship had directed, my lord, initially directed, my lord, had dictated an order, my lord, directing affidavits. After that, my lord, it was pointed out to your lordship that there is a delay, and your lordship was pleased to, my lord, pass this order, my lord, directing the appellant's earlier advocate record to appear. The matter was, my lord, due to appear on 11th of May. My lord, I understand, my lord, before the vacation. There are, my lord, applications pending before the my lord, the honorable suit court. They are, my lord, taking adjournments there, citing, my lord, the appeal is pending here. That is the, my lord, only difficulty. May it come up as to be mentioned, or your lordship, anything. My lord, it was
We will not hear the appeal before this, only 3 days. Only application I have indicated, please pass on the slip. Your rhetoric will not improve the case. Please pass on the slips. Pass on all the slips, applications and motions.
May I have your,
No hearing matter.
may I have your lordship's leave to file an
Just
appeal?
wait first.
May I
Nobody.
mention a matter, my lord?
Then why? What for?
My lord, for listing on Thursday, my lord, there are three
We can't
matters
say
where
it.
notice.
It's an application. Pass on the slip. If it is a motion, pass on the slip.
This matter is related to PNC School Service Amendment Act. Lordship.
Application or motion, madam. Give. Why you are mentioning? We said, please pass on all the application and motions.
My lords, with the utmost of respect, my lords, could I just please make a submission, my lords, to supplement what my colleague has said? My lord, this is no application of motion, my lord. It is that that matter, this contempt matter that your lordship had proposed to hear last Thursday, but which could not happen. My lord, it's my humble request.
Mr. Kozla, before this side of the vacation is very not possible because there are urgent matters which we have to take up. And if the matter can wait till, then we'll see. Only 3 days are left before the vacation.
I will just say one thing, my lords. It is my experience over the last 15, 20 years that fraudsters, contemners count on inability of the court to devote time to hear matters of fraud because they are by very nature complex.
Let us
Your
see.
lordship may not allow that premium to them. Don't hear the contempt matter, my lord, only hear that recall. That's all.
Understand. Let us see. Let us see. We'll see to it. Those motions have been given. Let us see.
Well, I have an application, well, very urgent.
No mentioning application, pass on.
Well, if it's not listed, well, KMK's
Sorry, we
bank
will not
account
say
will be
that.
attached.
You just pass on the slip. Just pass on the
May I,
slip.
with your lordship's leave, mention this matter? It was supposed to appear today. Your lordship will recall this is regarding to the Sanchayani appeals, my lord.
We are not hearing any appeals now. Sorry. Yes.
Well, the only thing, well, this matter, your lordship said directed to be listed on the 11th of May.
Maybe.
And
Maybe.
action.
No
very
contest one. No contest one. Only the new motions give.
Yes, it's a new application.
It's new motion only.
Lord,
Yes. Yes.
May I have your lordship's leave to file an appeal without certified copy?
When the order was passed.
10th April, I have applied, my lord, but till now. it
10th
has not
April
been
we are on today is 16th. So 1 month has gone.
Only I would like to, my lord, 10th April, my lord, order has been passed till 24th, my lord, I applied, but it has.
Maybe,
order has
sir,
not been
maybe,
drawn
sir,
as
if you can come for a leave without the certified copy, you could have come earlier within the period of limitation. Sorry, we will not. I have refused every member of the bar on this count. I will not give you a preference.
My lord, the matter has been made part heard and it is continuing in hearing.
I do not know why you did not come earlier within the period of limitation.
My lord, it has so happened that, my lord, what,
Sorry, I have refused every member of the bar on that count. If I give you an indulgence, that's a discrimination.
my lord, I am not a party in the proceeding. What
I
has
do
been-
not want to know anything about it. We will not grant you once the limitation has
my
been.
lord, I will not get the certified copy because minutes has not been
I
drawn.
do not know. I do not know. You'll have to go and pursue the matter there.
কবে আছে ওখানে?
Yes, call.
I have been told that I will be.
I have refused every member of the bar. I will not discriminate anybody. Everybody is equal to me. Other members of your bar, your brethren fraternity will, I would say they put a finger on me.
The difficulty
No,
is that
sir,
it has
no.
been made.
Your
part of the
persuasive
law.
appearance is well appreciated, but
It's not
no,
that, but
sorry, we are
no,
equal.
it has been made, my lord, parted.
No.
I'm not
No, sir,
implementing
we
that.
can't. Yes,
Kindly allow, my lord.
Well, the interim order has expired. Item number 1.
who is for the other side?
What are the official liquidator?
Lord, I'm
Where
from
is,
official liquid led by Ms. Tanushree Dashgupta.
the matter has come up. The matter is listed today for extension of interim order. So let the interim order granted earlier be extended for a period of 4 weeks from date or until further order, whichever is earlier. List the matter 1 week after the reopening of this court following summer vacation. Let's call the next.
Mother, for extension of the ad interim order. Got it.
কোথায় আছে আগের order? বলছে extension of interim order? Item number 3. বলছো new motion?
Extreme sorry. Apologize.
Yes, who is appearing? Mr. Orindam Paul. Where is Mr. Orindam Paul?
Well, item 3, my lord, item 3 IAPA for the appellant. My lord, there is an application under section 34, my lord, which has been dismissed. I was, my lord, the applicant in section 34 application. Well, the matter needs to be heard. Your lordship had directed us, my lord, to furnish security. We had, in fact, before the learned single
Where
judge,
is the application?
furnished the entire security.
Where is the application? What is the total amount?
My lord, the total amount had been calculated, my lord, by the learned single
You
judge.
have
That
to,
time.
you have to deposit the cost as well.
Well, I'll do that. My lord, kindly pass an order, my lord. I shall deposit, my lord.
Because I find the cost is also imposed.
That's it, my lord. I'll deposit it without prejudice.
My lord, if I may, my lord, my 75% was directed to be deposited, my lord.
Now they have to deposit
My
the
lord,
balance.
my lord. My lord, maybe come back on the next day with.
My lord, with the calculation of the balance amount, let them intimate to us, my lord, what is the balance. We'll of course have to scrutinize it. We are, my lord, a public sector undertaking. My lord, we'll do that and deposit that money. But my lord, subject to that, there should not be any steps taken for enforcement of, my lord, the word.
My lord, we'll come back, my lord, on Thursday, subject to my lord's convenience and give the
Thursday.
calculation.
Okay, my lord, Thursday. Well,
After all,
After
this
the-
is like a first appeal.
My lord,
So we have to hear out the appeal.
my lord,
Now they can always be put to terms because
My
it
lord.
is a money decree.
my lord.
So they have to deposit the entire balance amount.
My lord, I am told, my lord, subject, my lord, my instructions are that the amount payable after considering the cash deposit which they have made is approximately 4 crores 33 lakhs
let them give us-
14,813.
let them give us the calculation. Let us look
My lord,
into it.
this is something which has been certified by a chartered accountant who's calculated the difference which has to
My
be.
lord, let them give us the computation. I cannot accept the chartered accountant's calculation without going. I'm a public sector undertaking.
No, whatever, but as per the award, everybody knows that what is the amount.
No, my lord, here the calculation of interest, my lord, under NMSME, my lord, peculiar calculations have been made. My lord, whatever, let them give it to us. Let us scrutinize it.
My
We'll
lord,
deposit the
we
money.
made the calculations as per the MSME Act only. It's certified by a chartered accountant.
Well, they have to give it to us. My lord, I think, my lord, at least we have
Give
to, my lord,
Give it in the
Why-
course of the day only, my lord.
Just give it to them.
well, we'll have to, my lord, send it to, my lord, the HEL office. It's Hindustan Aerolot,
Have
my lord, Bharat Heavy Electricals. They'll have to see it.
But you'll have to deposit, then we can't
No, I am not saying I'll not deposit. But, my lord, I have to, my lord,
come on Thursday
My lord,
or
we'll
come
back.
after the vacation.
well, immediately after the vacation.
Yes.
Thursday, my lord, I will be not be there. That's why. Immediately after the vacation.
The respondent
My lord, may I seek
would disclose the amount which the appellant is liable to pay in terms of an award to the advocate and record of the appellant in course of this day. Stop. The appellant shall verify the same and shall communicate the stand of his client on the next date of listing.
My lord.
List the matter on 6th.
My lord, may it be kindly any day after the 8th,
Sixth.
my lord. My lord, I'm being led by Mr. Chaudhary. Shobhat.
6th.
My lord, maybe any day after the 8th, my lord. Any day after the 8th, my lord. My lord, I'm being led by Mr. Chaudhary. He's made one.
So at the moment, my lord, we are only concerned with the matter of
Only
deposit.
on the stay application, don't worry.
Only the matter of deposit.
Kindly would my lord consider any day
What
after.
is there? We have already indicated a stay would be granted, even Mr. Chaudhary appears,
My lord,
but subject to the conditions that they must. So there is no difficulty. We have already expressed our mind.
my lord, my lord.
My lord.
Whether he appears or you appear, the same result.
Grateful, my lord. Grateful.
Yes.
Sir,
दोषी के नाम पे mention policy না হয়। তাহলে আবার তো-
Yes, call. Draft. सब जानिए नहीं ओ तो আমি ভাবলাম যে আমি তো ঘাবড়ে গেলাম yes the appeal is dismissed no cause
Item 2, my lord, I appeal for the petitioner.
We therefore modify the order passed by the tribunal to the extent that the Secretary, Department of Health and Family Welfare, Government of West Bengal shall issue the release order within 2 days from the date of this order. In the event the said order is not issued by the authority, the petitioner will be entitled to rely on this order, and all concerned shall treat the same as deemed order to release in favor of the petitioner to take off any other post that the petitioner intends to.
Instead of 2 days, it hasn't been 7 days. My lord, your lordship will find 21st is the last date. No extension is granted to me. My lord, I will be in complete.
21st is the last day note
My lord, may I get a plain copy, my lord? There is a, my lord, with regard to server copy, my lord, there is a disturbance in the website, my lord. For last 2 days, we cannot access.
sorry we do not have the name of the respondents here can you supply the name of the respondents please supply the name of the respondents because the judgment does not indicate because you have not given এই পাতাটা চেঞ্জ একবার পরে করে দিই ঠিক আছে চেঞ্জেস এই নামটা লিখে নাও নিয়ে নাও
My lord, may I get a plain copy order, my lord? As because the server is not working, my lord, may I get a plain
server is working why not it is not
My
working
lord, yesterday, my lord, nothing would be from last.
Thunderstorm.
Nothing is working, my lord. From yesterday also, my lord, it was
now the thunderstorm is over
yesterday, my lord, the entire day, my lord, it was not working, my lord. If your lordship kindly allows me, my lord. Or else I would have never made, my lord. I know, my lord, your lordship's order is the very next day, that very day gets uploaded. But now the situation is such, my lord, that compels me.
এটা করে দাও let the plain copy of this order be supplied to the respective councils on an undertaking that they would obtain the certified copy thereof if you violate the undertaking then you will
No,
be
but
in
today
trouble.
itself, I will apply
We
for
are
the certificate.
going to list many matters very recently
But today
just
itself, I will
immediately
apply.
after the vacation I have directed the office to trace out all those where an undertaking is given for all these purposes and have not been honored contempt
But today itself, I will apply for the certificate copy.
not applied you'll have to obtain it
I will
not application will not do
urgent
Yes.
certificate copy.
Be careful, find out any of your matters where you have given an undertaking, you have not done it.
No, my lord,
It will list immediately after
it
vacation.
never, it has never happened to me, my lord.
Check क्यों लिखना है?
इनको भी तो take দিয়ে দেবো, আপনি certificate को apply করে দেবো।
Praying for an extension of the ad interim order. I mentioned the matter on Saturday.
Let me see what is the nature of the interim order, sir. Where is the, have you given a notice to the other side?
Yes, my lord.
Where is that?
I mentioned the matter upon notice to the other.
Sir, please show us. Mentioning slip টা কোথায় আছে? এটাই তো আছে।
My lord. না না আরে আগেরটা
Yes. ঠিক আছে। Despite notice that the matter would be mentioned for extension of interim order, there is no representation on behalf of the respondents. Affidavit in opposition has been filed.
Yes, my lord. I'm filing it in the.
Opposition has been filed.
My lord, we have filed opposition to the order 42 and Rule 27, and they filed affidavit in opposition, and we have also filed affidavit in reply as per the last order.
Then keep it with you. Stop. Let this matter be listed 1 week after the reopening of this court following the summer vacation. The interim order granted earlier is extended for a period of 6 weeks from date or until further order, whichever.
My
is-
lord, one indulgence, my lord, as per the direction of the court, I have also filed the paper book, but that paper book is lying with the court, my lord. Kindly give a direction.
Sorry, we'll consider on that day. Yes, next.
Much obliged. Great.
Have you served? Where is Mr. Kalyan Kumar Chakraborty?
Last week also they didn't come, my lord. My lord, I got rejoinder and affidavit of service.
Why you did not get it mentioned? Why the order was not extended? Interim order was still 1 week after the Christmas vacation.
Interim order has been extended, my lord.
Where?
Last week.
When?
Last
It has been extended on.
Last week, my lord, order has been passed for extension of the interim order. On Friday, my lord.
Then interim order is already there. এ রে, আমরা কখনো করি না। It was operative. Christmas vacation for the year 2020. তার মানে 2024 পর্যন্ত তো interim order. খেয়াল করিনি Christmas vacation. It should be a summer vacation.
My lord, I have
What is this rejoinder? Where is the opposition?
affidavit of opposition.
No, opposition must come. Has it been filed?
Yes, they have given me, sir.
There is no opposition. Hey, we can't accept the rejoinder in this fashion. And why the rejoinder? Why not the affidavit reply?
Affidavit reply they have given me, sir.
Then what is this rejoinder?
Here is the opposition counsel, sir.
दिए दो फिर आगे rejoinder.
Opposition and opposition has already complete, my lord. Now it is under hearing stage. In the meantime, my lord, review application, my lord, has been filed, my lord, review application.
Where
Previous order, my lord.
review of which order?
That is, my lord, order dated, my lord, 15th of March. That has already expired as far as this order is concerned. That has already expired
What expired?
because, my lord, this is under about 3 weeks, my lord.
It was
No, I find you were not there. It is extended 1 week after the Christmas vacation.
That is, I am not.
You don't care to appear. What can be done?
No, that is not.
That is on 12th
No
of 12th of May. It has been done.
No copy has been served as far as
It's
extension
not
order is
necessary
concerned.
extension.
No, my lord, no copy has been served.
Why it is required? It is extension is by virtue of this mentioning.
Without copy, my lord.
Are you not getting an extension on mentioning or listing the matter?
That is contempt proceeding, my lord. Contempt matter, my lord.
I am simply
As far as the extension is intermediate order is concerned, that is not. No application has been served, my lord. No notice has been served. my
what are you talking about? The
Yes,
matter
my
is
lord.
already appearing in the list.
That is that
interim
that
order
is
was
contempt
already
matter. That
granted.
is CPAN number, my lord.
Sir,
Not a CAN
interim
number.
order was granted in the month of March.
Yes, my lord. That order has been passed, my lord, 15th of March 2023, my lord.
We state the operation for a period of 8 weeks.
Yes, my lord.
8 weeks means what? From March for 2 months. It will take us to May.
15 May.
So on 12th May, it has been extended.
But that I am
You
not.
did not
I have
appear.
no
What can
notice,
be
my
done?
lord. That's
It was listed. You did
listed,
not,
but under the, my lord, contempt proceeding, my lord.
not contempt proceedings. Anyhow,
Yes,
that has been
Your Lordship,
extended.
kindly come to my lord.
We will modify this order. Now you have filed a review.
Yes, my lord.
So we have to hear out the review.
My lord, review main point, my lord, that, my lord, that said post, my lord, accordingly, my lord, you will see, kindly come to my lord.
Yes.
That is memorandum, my lord. Annexure, my lord. Annexure B, my lord. Number, my lord, can review applications 72, my lord. That is the RTI information. And then, my lord, approval of the competent authority. As far as RTI calls application is concerned, that has been rectified.
Now,
by the authority.
Now tell us one
But
judgment.
difficulty is that, my lord,
Sir, give us one judgment
yes, my lord.
that a review of an order is permissible.
Yes.
On the basis of a new document which you want to rely before the court.
So that is not my argument. My argument only that, my lord, taking back the post, my lord, that is not possible according to my instruction, my lord.
I am again asking you, sir, review, you know the jurisdiction of the review.
Yes, I know.
There must be an error apparent on the face of what? Record.
Yes, sir.
So whether all these documents were there on the record, it was not, because it was an ex parte order, which
Yes.
was, the order which was passed in your presence. And therefore, you could not produce those documents at that point of time.
Yes, that is true, my lord.
Now, question is that what you have said. The second ground is the discovery of new and important documents with despite due diligence was not within your knowledge.
Yes, sir.
Now tell us that whether this document was within your knowledge or it was not within your knowledge. Sure.
As far as the record is concerned, that is not my knowledge. At the
No,
point of
I am asking you, sir.
Yes.
When you appeared,
Yes, sir.
Whether you were aware of this particular document in existence or not.
That is not, that is not my knowledge as per my
I
instruction.
am asking you, sir, then you have to state that when you derived the knowledge, how it came to your
As
knowledge.
far as right to information is concerned, my lord, that is absolutely knowledge, but that has been rectified after your lordship.
I am not, sir. Are you aware of the review jurisdiction, sir? Review under what provision of law, sir?
Review, my lord,
I
that
am asking you, review is under what provision of law?
You can apply for variation vacation.
Your lordship kindly come to my lord, page 5, para 10. That is my main argument, my lord, as far as this
Sir, I am
take back is
asking,
concerned.
no difficulty, sir.
There are difficulties, my lord, which I faced. my lord.
Well, there is no difficulty that you have, that's your main argument or main case. Whether this is a case which requires invocation of review jurisdiction. I am simply asking this question.
Yes, my lord, that needs.
Show
my lord.
us
Yes.
that under
Because your
what
lordship kindly
ground, under which provision of law the review is permissible, and on what ground the review can be entertained. Tell us. These are the two things you must tell us. This is the scope of review jurisdiction. This is a provision of law relating to review. Tell us that you come within that.
Review only, my lord, applicable only, my lord, that the order has been, my lord, passed, my lord, without the, my lord, provision of law, my lord. Because, my lord, your lordship kindly come to, my lord.
What I could not get it. Review is applicable where the order is passed without provision of law.
Yes, my lord. Because, my lord,
It is then an erroneous decision.
because, my lord,
It is something which is erroneous.
my only point, my lord, is that, my lord,
I am asking you till this time you have not told me that what is the jurisdiction
yes, my lord.
exercised by the court under review.
What provision of law? What provision of?
If you kindly take it tomorrow, my lord, I will.
You don't know. You drafted the review. Have you not drafted the review application?
I am drafting, my lord.
You have, I believe so. So you don't know under what provision of law the review lies. You don't know that what are the grounds for review. You don't know anything. And you drafted the review petition.
I have mentioned in the ground, my lord. Your lordship kindly come to my lord. My review application, my lord. That is page 4, my lord.
Page,
Grounds, my lord, 9, 10. Or that the relevant post public inspector level 5.
just I am asking you, sir, let us see. You are taking us to memorandum of review.
Yes.
Page
Page,
4,
my lord,
ground 9.
Page 4, my lord. Para 9, 10.
Is a ground for review.
Yes.
Is it a ground for review?
Ground for, my lord, the order has been passed.
Sir, the difficulty is except this I can say because we are live. A person before drafting any petition, he must first thing satisfy his conscience whether the the petition which he is filing is in accordance with the provisions of the law. Whether there are sufficient ingredients which are required to be pleaded in relation to that provision are there or not. A person drafted the petition without knowing that what is a provision of law applicable in this regard, what that provision says. Tell me whether the judicial review power exercised under Article 226 of the Constitution and a power of review under a different provision of law against an order of the court are synonymous. You're talking about the judicial review. I'm simply asking you. Sir, you are not prepared at all. You have not applied your mind on the I would say on the case. Better do some homework, come back. It is better for you. We notice that there is a discrepancy in the order dated 12/5/2023, wherein the interim order was directed to be extended 1 week after the reopening of the court following the Christmas vacation for the year 2023. In fact, this court extended the interim order to operate till 1 week after the reopening of this court following summer vacation. So the order is modified to the extent that the interim order granted earlier shall continue to operate till 1 week after the reopening of this court following summer vacation or until further order, whichever is earlier. Stop. In order to give an opportunity to the respondent who has filed the review application being RVW 72 of 2023 to prepare himself in the matter, let the review application as well as the writ application and the contempt application be listed on 7th of June 2023.
My lord, one thing I would like to submit.
7th you submit. Yes, call the next. Yes, Dekhi. None appears. Let the matter be listed 1 week after the summer vacation.
Item 81, my lord, I appeal for the petitioner. My lord, I have served all the respondents. My lord, this is the affidavit.
You are challenging an order of 4th May 2023. Just give us 1 minute, 2 minutes time.
Unauthorized. Second unit from recognition D, that is unauthorized. তো সেখানে ট্রান্সফার করতে সেখানে ট্রান্সফার করলে কি করবে স্টেটের ব্যাপার বাট সো ফার দ্য স্ট্রাকচার and the recognition is unauthorized. আমরা ইন্টারফেয়ার করবো ওটা আপনাদের ব্যাপার ওটা আপনারা ট্রান্সফার অর্ডার করছেন আমাদের কাছে primary teachers training institute.
Where are you posted now?
There are two petitioners, my lord.
I am asking you, where are you posted now?
One is posted at my lord Shuri, another one is posted at Bhatol, Uttar Dinajpur. There are two petitioners. my lord.
Shivdi, you are posted.
Yes, my lord.
And the person who is posted in Suri has been requested to go and attend or take 2 classes in where? Suri itself, second campus?
No, my lord, it's Bolpur. My lord, my lord, one is in Bolpur and another.
Suri and Bolpur is hardly 15 kilometers or something, not more than that, or the same place.
My lord, only thing is this, my lord, your lordship will kindly.
That is what I was just thinking of.
My lord, only thing is subject to kind consideration. My lord, these second campuses, my lord, your lordship.
I understand, sir. 8 of them has I would say gladly accepted it. They are doing it. After all, whether their institution or campus is recognized or approved by the NC, what is this?
Well, neither NCT has
My
approved.
client.
NCPL.
No,
NCT,
NCT, my
National
lord,
Council for Teacher Education.
but that is the authority to.
Whether it is NCTE or not, then none of your business. You are a lecturer appointed. They are requesting you to go and take 2 days in a week. One lecture there. Do it whether the institution is approved, because you are still regarded as the permanent, I would say the appointed lecturer in a recognized school or approved campus. No difficult.
No, but I don't have any hesitation.
Only thing is that if you have to travel 18 kilometers, they have to think of that any conveyance or the traveling charges can be given.
No, my lord, only thing, my lord, there are 2 things. So if lordship kindly allows me, my lord. My lord, with regard to this part is concerned, my lord, there is also a writ petition pending. One application was filed before this honorable court. Your lordship may know, my lord, it's Tulsi Bokshi's case. But in that case also, NCT was not approved.
Tulsi Bokshi,
Yes, my lord.
all gone, no longer good. Don't say so. Justice Oshim Kumar Banerjee has also. I know it. I was there in education determination for a pretty long time.
No, my lord, we are not saying anything with regard to
That is
lordship's
what I'm
experience.
saying. So pretty long time. Now the question is again, it's a question of principle. You are an appointed lecturer in a campus which is well recognized by NCTE.
Yes, my lord. But I don't have an issue, my
Now
lord.
they opened a second campus. They say that the application is already pending before the NCTE. They have not taken any decision, but they have already, admitted certain students there. They say that we can't appoint a regular lecturer there unless the NCTE gives an appointment, gives an approval. These lecturers, instead of 5 days here in first campus, 3 days you deliver lecture here, 2 days you go there. Now, if it is a distant place, say around, as he said, 20 kilometers, then naturally you have to embark a journey, you have to go travel, you are entitled to something. No difficulty, that they will take care of.
No, my lord, if your
As
lordship,
a way of stipend or something allowances, they will take care of.
my lord, if your lordship kindly have a look at page 46 once. Page 46 once, your lordship kindly have a look.
All out of 10, 8 have joined. Only these 2 persons are creating problems. Yes, 40.
Page 46, my lord, page 46A is the type copy, my lord, if your lordship takes up page 46 and 46C. My lord, this is a notification issued by the government. My lord, the last line, last paragraph 2. The remaining
10
10
numbers of
PTTIs
PTTIs will be the second campus of DIET. I do not know what is this.
my lord, District Institute of Education and Training.
I thought that is something else.
No, my lord, it is, my lord, they impart,
I consider in a different way that
my lord, they impart education to the teachers. Now, my lord, your lordship will find will arrange separate batches to be trained in the second campuses after obtaining the approval of NCT. My lord, this is the government order. The government order says also, my lord, it can be only done after the approval has been granted by the NCT. Now, my lord, there are 2 authorities, the board and the
I
NCT.
understand, sir. Now they have said that pending application, suppose if the approval comes with a retrospective effect, what they will do?
And my lord, your lordship will find they have already, well, initially 50%.
Will you go and deliver lecture or will you not go and deliver a lecture? Straight away tell us the answer.
My lord, with regard to this,
You
first
can't,
campuses,
you can't, then we are deciding. If you can't, then say. And where is the second one? One is from Birbhum to Siudi to Bolpur. Then
Uttar Dinajpur.
Raigons to,
Raigans to about
where is
Bhatul.
posted?
Raigans to Bhatul.
Bhatul.
Bhatol is how far?
I'm been told at more than 50 kilometers. I'm not sure about my learned senior friend can say.
You'll have to say that. How far?
And
একটু জেনে নিতে হবে। রায়গঞ্জ থেকে তো কোথা থেকে দেখি?
Special analysis or stipend, whatever.
রায়গঞ্জ।
This has to, you can't compel them to go and. Today, one campus.
রায়গঞ্জ
Yeah.
HUL Bhatul 46 kilometer. Sorry, 46 minutes, 26 kilometer.
26. No. Pay, you'll have to pay.
Whatever the available, that will be.
What available? You have to. You have to. Will you or will you not tell us?
For the interest of the students community, because the teachers are trained on the right to education act will be suffered, the students will suffer.
Yes.
We leave it to Lordship. My lord. My lord, your Lordship kindly indicate your Lordship's order, my lord. We are a group A officer. We should be getting whatever, my lord, the traveling allowances, whatever is there, in accordance with to our post. My lord, they have said, my lord, we will be getting nothing. My lord, that is also one of the issue there. Well, let your Lordship may clarify that part of your Lordship's order.
We are keeping this matter day after tomorrow. You take an instructions. If they can't, then we'll have to make certain observations.
জেনে না ওটাই instruction.
Yes.
The lecturer, the stadium. No, whatever the transportation around.
No, the difficulty one kindly visualize. He has been appointed in a particular institution. Please consider institution permanently. Now he is discharging his duties. Now you say that, please, there is another institution. Please go and also deliver lecture there. If you compel him to go there and give a lecture with a very award object, I must say, very good object, that they wanted sometimes the faculty lecturers, apart from faculty lecturers, some guest lectures are being conducted, bringing the person from outside. I appreciate it, just to enhance the, the knowledge, enhance the whatever, the excellence or something of that kind. This is appreciable, but at least he has to embark a journey of 30 kilometers, 28 kilometers, 15 kilometers, 20 kilometers. Then in that event, will you not take care of that? If he goes there, then he'll have to.
But not AC card, but
What?
not any AC card will be provided there, but I need the bar.
According to
No, it's not that.
post
You'll have to give them some kind of allowances.
According to his standard, that will be.
Make it a fixed one every month. Should a special allowances, I can understand. But that should be a fixed one. The difficulty is when you say that you have traveled, please give me your all these things, the tickets and all, how you have gone. He may have gone in his car because he's a lecturer, must be having a car. Or maybe a motor bicycle, whatever, the petrol. Or if you provide him a car, a decent car, who will come, pick, go there and drop. Why will go a lecturer?
He is a group A officer, my lord.
Lecturer post is quite a high post. The additional government pleader demands the AC car, and then he say that somebody who is a senior government council, he will say he will go in a bus.
Mr. Mukherjee is having two cars. One can provide.
Can't expect a lecturer that to travel in this fashion. ये तो actually चले जा रहे हैं. Mr. Mukherjee, ascertain, come on day after tomorrow, ascertain and tell us. But he'll have to go, sir. This is a service to I would say, the mankind.
I will surely convey.
The students are the futures of the nation. Don't forget that this teaching, the job, may I use the word job, though I don't consider it as a job. It's a teaching responsibility. Once you have taken, don't consider that this is a 9 to 5 service. You are building a nation.
That's true.
Please take instruction at your end. After hearing the parties, we feel that the learned additional government leader must take the requisite instructions from the client, from the state, relating to the issues involved in the instant writ petition. List the matter on Thursday's date. Let's call the next.
Deep report. Now, item 82, my lord, your lordship has heard this matter, my lord. Mr. Dibendra Narayan Rai was appearing for the petitioner. But today is supposed to judgments were to be placed before your lordship, my lord.
You don't know what for.
My lord, this is a matter, my lord, your lordship will recall, my lord, excess of overdrawn amount has been said to be recovered.
Service book,
Yes,
that
my lord,
was
that matter, my lord, your lordship has heard that matter.
what are the judgments? We says.
My lord, there are two judgments which has been handed over to me, my lord. He's on his legs, my lord. I beg apology on his behalf. He's on his legs before courtroom number 1.
Where is the judgment?
These are the two judgments delivered after Rafiq Masih. These will be recent judgments.
Hamas Daniel.
But
Hamas Daniel has not considered the 141 decisions.
What?
Hamas Daniel has not considered Chandipusha Dunyal.
Chandipusha Dunyal was considering Rafiq Masih itself. Well, that is the reason matter was.
That's why the matter was referred to the larger bench.
And larger bench
said that Sambabu Verma and the other one, 142. And only Chandipusha is 141. The main judgment, Chandipusha has not been considered.
Rafiq Masih ka আছে? Rafiq Masih ka আছে?
এড়িয়ে যাবো ওইটা
আমি আপনাকে দিয়ে দিচ্ছি।
ভোটে নেই যে এসেছে অনলাইনে আছে যেটা লার্জার ভিতরে
এটা চারটে।
ওটা নিয়ে টানাটানি করছে
না, এই কি কেন করছেন? আপনি আমি দিয়ে দেবো আপনাকে ফোন।
না পেন্সিল করো
এটা লার্জার বেঞ্চ আছে।
2005 to SCC page 6
The other
This
decision,
is
my lord,
not a Rafik machine in that sense. Where is the actual judgment of the Rafik
my
machine?
lord, I do have, my lord, I got
He has
copy
given
from
a
my
different
learned senior
judgment.
friend. My lord, this is a copy, I've got it from my learned senior friend, my lord. My lord,
This is not a judgment of Rafik Masih.
my lord, that is, following Rafiq Masi, my lord, it was decided.
মানে মায়া টেলার্স আছে
First, my lord, your lordship will find paragraph.
Where is the actual judgment of Rafik Masih? That is what we wanted.
Now, my lord, what my learned senior friend has just now said, Chandru Prasad Unial was not dealt with. If your lordship takes up paragraph 4, well, that was the reason matter was referred to a larger bench. That's because the
Please
conflict.
do not interrupt. We have gone through that.
paragraph 14. Very vital. Thank you. Lord,
Now this Rafiq Mashi after this three judge bench is a 141. 2015 is a 151, 141.
Only Chandi Prasad is the 141.
Rafiq Mashi's subsequent judgment is a 141.
But larger.
141.
Three judges bench.
Larger bench did not rule out that all the three judgments. And secondly, the larger bench did not consider the two very important judgments which were there. One was a Sayyid Abdul Qadir judgment and another was a BJ Akhara. Did not consider.
Sambabu
It
Bharma
was
considered.
maybe, but they did not consider that.
Kindly say that 2015, 14.
And Sayyid Abdul Qadir was the 141.
142.
No. Sayyid Abdul Qadir is 141. Where are those judgments, please? Are you not understanding that what point he has taken? How to argue these points, are you not aware? It is the judges who has to find out a point for you.
Sahib Ram was considered by the.
That is a different, I am saying. Sahib Ram was considered. Sham Babu was considered. But Sayyid Abdul Qadir was not. And BJ Akhara, I do not know, Akhara or what, that was not considered. And very interestingly, the three judge bench did not answer. The three judge bench refused to answer the reference.
Yes.
What it says is that I find that these two judgments are passed in exercise of 142 and this Chandi Union or whatever. Chandi Prasad is a judgment under Article 141. No declaration of law. But it appears that a larger bench decision were not considered. Sayyid Abdullah Ali. Where are those judgments? Can you give?
Chandi Prasad Union has got.
Sorry. That is what I am asking. You give. Correct. How it has dealt with. Say in a peculiar, the exceptions are there.
Yes.
Did not rule out that those are applicable. Those few exceptions have been carved out therein. And this present case is not coming under the exception.
Present case. Yes, ma'am.
Chandi Prasad has really bypassed it, saying that that is a special facts there. And this is a special, another fact here. Only paragraph 14 creates a problem, which is considered to be Article 141.
In this case, if your lordship considers peculiar circumstances,
No
it is
peculiar.
better that the family has got pension. The husband is missing for over from 2010.
That is what I'm saying.
And he was facing a departmental inquiry when he went missing.
Give me that.
Chandi Prasad.
Not Chandi Prasad, is with me. Sayyid Abdul Qadir.
Because of the fundamental rules.
Just wait. Because I know this is a three judge bench. That's why I said. Sayyid Abdul Qadir is a three judge bench decision.
What Mr. Mukherjee was referring to is the Rafiq Masih reference case is also three judges.
That is why I say the community of Daudi, that is the committee of the Daudi Vora on the last occasion last year said
That 3 judges and 2
5 judges. And then it says that if it is of a higher quorum, then it is binding. If it is a lesser quorum, then not binding. If it is a coordinate, then if you want to take a dissenting view, then it is only course which is open is to refer the matter to a chief justice. If you do not, then the subsequent judgment is not a good law.
But it was not on that aspect Mr. Mukherjee submitted. He submitted that 3 judges bench has, my lord, confirmed Chandi Prasad unions. This is what he had submitted.
But if the 3 judges bench confirming a Chandi Prasad runs counter to 3 judge bench earlier of the Sayyid Qadir,
It has,
what does it mean?
it has considered, the Chandi Prasad union has considered Abdul Qadir's case.
But if it is wrongly considered, then what? I lost on that ground. I tell you, the same argument was advanced before the division bench presided over by Justice Bhaskar Bhattacharya in Jawaharlal Saha's case. Same thing happened. A 2-judge bench decision considered the earlier 3-judge bench decision of the Supreme Court and then say, no, this is the law. And that was a case based on a special facts. That 2-judge bench decision was affirmed by another 3-judge bench decision of the Supreme Court.
Kindly consider this peculiar.
I'm saying that please go 2006 volume 1 or 2 CLJ, Jawaharlal Saha.
2006. CLG.
Jawaharlal Shah.
Now, what is the effect? What you are saying is, I tried to argue.
We were only submitting, kindly consider the peculiar circumstance of this case. The husband goes missing in 2010 while facing a department.
That is a different issue. I am just talking about the proposition of law. What is to be done?
Now, what should be done?
Because a latter 3-judge bench appears to be in conflict with the earlier 3-judge bench. And if the earlier 3-judge bench was not noticed at all, then what? Then I wanted to propagate one theory. I could not succeed. That is the doctrine of implied citation. Because the earlier 2-judge bench, if considers the earlier 3-judge bench and explained it, then that 2-judge bench, if it is cited before the latter 3-judge bench, then it will be deemed that the 3-judge bench decision was also cited, was not accepted.
Matter, with great respect, matter has to refer to the larger bench for deciding the issue.
No.
So what should be the correct law?
We are deciding it here. We'll decide it here.
There's already a single bench order going to the larger bench of presided over Justice Subrata, which is supposed to deliver the judgment. It has made CAV. Hearing has been concluded.
What for?
For the recovery. It was made by the State Bank of India with regard to pension.
Where it is pending?
It is not pending. It is pending CAV.
Where?
High Court.
Special bench, larger bench.
Larger bench, presided over by Justice Subrata.
How much? Composition? 3.
3 judges. 3 judges. Justice Subrata Thalik were presiding over Justice Krishna Rao and Justice Supratim Bhattacharya.
Then why not we wait for the decision?
That will be better.
We'll wait for the decision.
I leave it to Lordship.
But we will stay for the time being because prima facie we are.
No, the recovery has already been made. It is already in the consolidated fund of the state. And my lord, there is no law. If a direction is given to us, my lord, we cannot.
Anyhow, we'll take care of that. If necessary, if you won 3-judge bench, then we will.
No, but there is a stay for a limited period because tribunal directed for refund of the amount. That's a difficult.
No, we'll grant you a stay. That's why we're saying, but you will keep it. But if they are deprived, then they are entitled to interest. Ultimately, if they are found.
We keep it a separate account.
No, it's not a separate account. We are coming and dictating the order.
Taking the order for the.
But yesterday,
dictating-
yeah, just, but yesterday your lordship heard this matter for quite some time. But I was directed to produce
I-
two judgments, Lord.
After the argument was substantially advanced by the respective councils, the matter was directed to be listed today to dictate the order in open court. At this juncture, the learned additional government pleader submits that the point involved in the instant writ petition is a subject matter of reference before the special bench,
Lord, that is a different issue altogether, Lord.
where the hearing has been concluded and the matter is reserved for delivery of judgment. We inquired from the learned additional government pleader whether the similar and identical point has been referred to a special bench, it is submitted that the point of reference relates to the power of the employee to recover the excess amount paid to the employee, and the steps are being taken to recover the said amount from the said employee, either from the future salary bill or from the pensionary benefits. We find the identical point having involved in the instant writ petition, and therefore we feel that the matter should not be proceeded with until the judgment is delivered by the special bench. In view of the above, the matter is adjourned sine die. Liberty is granted to the respective parties to mention for listing of the matter after the judgment is delivered by the special bench.
Let it be kept as part heard, Lord.
Sir, we don't keep it. Very first line, we have already indicated the
But in the meantime,
substantial.
the interim order will be stayed for a limited.
No.
Acha. Considering the fact that the tribunal has directed reimbursement of the amount deducted from the pensionary benefit, we feel pending final determination, the operation of the order of the tribunal should remain state. Stop. In view of the above, there shall be stay of the operation of the order passed by the tribunal, which is a subject matter of dispute in the instant writ petition, till the disposal of the writ petition or until further order, whichever is available.
And the service book be kept in the records. Service book yesterday.
Yes, let the service book filed on the last day be handed over to the learned additional government pleader to be produced as and when directed by this court.
Yes.
Yes, call the next.
I'm grateful.
Now we have indicated if it is wrong, you can come.
No, even the judgment by
that's
the
why-
larger bench goes in my favor, I shall come.
That's why I say, you say no. That's why I say I recorded. That they have said. If it is a wrong recording, then you can come again.
All right. I'm grateful to it. Time for the petition.
Service.
Order is page 54, my
Yes.
lord.
Yes. We have seen, she joined in 2007, but passed the Madhyamik examination in 2013 without seeking any approval from the authority. Now, whether you will recognize that particular acquiring the degree or whatever, that a pass certificate of a Madhyamik examination subsequently, whether you can put her above the gradation list, because that is the criteria. Madhyamik examination is a basic criteria for that promotional post. But whether the joining without permission, whether any permission is at all required or permission is not required, tell us. Sir, she was appointed in 2007. He was appointed in 2013, no doubt. One who has come earlier must be placed above in the gradation list. But his contention is different. He says, yes, so far as that the posts below the lower division clerk, if the gradation list is put, she is put at the higher position, no grievance, because the Madhyamik is not the criteria there. But once the lower division clerk, the Madhyamik is the requisite educational qualification. Then in that event, a person who did not have the Madhyamik qualification, did not qualify the Madhyamik examination, but qualified in 2013 without seeking your permission.
15.
Whether he can be or she can be put above. A person who does not have the requisite educational qualification for a promotional post, will you promote that candidate to that promotional post? I am asking you, first question. Can you? I am against asking if the promotional post has the requisite educational qualification as a condition. No, I understand. That's why I'm asking you. I understood. So lower division clerk has two avenues of, one by direct, another by promotion. Again, direct, you have said minimum educational qualification is Madhyamik pass. In promotion, do you have anything? Yes.
Is not essential.
Is not an essential qualification. Show us, they're out of court. The moment you show us, they're out of court. Show us. Sometimes when that is the only point.
And my objection, my lord, which is
Sorry, that is the only point.
Yes.
If for promotional avenue, the educational qualification is not a bar, no problem. He is out of court. He's out of court. Admittedly, somebody who was joined earlier must be placed above him. He's out of court. Show us that provision. Look at, no, this is not expected. It's small matter which can be disposed of within 5 minutes. Unnecessarily, you are taking time. No, Mr. Mukherjee, this is not expected. At the state should come ready with all. You are taking a plea and you do not know that what you have to place. To enable the learned additional government pleader to prepare in the matter, let this matter be listed after summer vacation. Come.
Already I have been transferred from my, due to the case, my lord.
Transfer is not an issue here, sorry. The issue was gradation list, that's all. Yes.
After vacation. আপনি এবার এসে দেখিয়ে দেবেন।
Give me. None appears in support of the writ petition. Record her appearance. Dismiss.
In this matter, I am applying for the respondent number 8, my lord. But on last occasion, my lord, the petitioner did not appear. Pass over this matter.
I am for the 100
On last occasion.
petitioner, my lord. I am for the petitioner. I am led by Mr. Akazim Mukherjee. He is suffering from high fever. Lordship, I am praying for not this week. Kindly.
Since when he is suffering?
My lord, this directed tomorrow. Actually, he is suffering high fever.
Why didn't you circulate a letter to him that you will be
On last
asking?
occasion, my learned friend took time, not appear, didn't appear. That's why. this
Anyhow,
matter-
it is submitted on behalf of the learned advocate on record of the petitioner that he is suffering from high fever and unable to attend the court. In view of the above, let this matter be listed 1 week after the reopening of this court following summer vacation, so that it will come in the supplementary
Yes,
list.
that's true, my lord. On last
Yes,
occasion, it pass over.
what
That's-
can be done? You may suffer.
That's why, my lord. And this is the last chance, my lord. Only, my lord,
You can't predict that he will not be ill. Let him recover for the time being. Can't say so. Yes.
I beg to appear on behalf of the petitioner. Affidavit of service. My lord, only thing, my lord, this is my lord. My lord, initially, my lord.
Just 1 minute. Where is your tribunal application?
My lord, it appearing at page. Starts from page, my lord, page 15, my lord. 14, my lord, it starts from page 14.
Page
Page 14, just after affidavit.
14.
1/4, my lord. Just after affidavit of this request. P1.
After perusing the impugned order and upon reading the contents of the writ petition as well as the tribunal application annexed thereto, we find that the tribunal proceeded on the basis of the report filed by the learned advocate representing the state government and disposed of the tribunal application without looking into the averments made therein and the cause of action pleaded there and the cause of action made and the cause of action pleaded there. We therefore feel that an opportunity must be given to the respondents to file affidavits in the instant writ petition. Accordingly, the respondents are directed to file affidavit in opposition within 2 weeks after the reopening of this court following the summer vacation. Reply, if any, shall be filed within a week thereafter. The writ petition is returnable 4 weeks after the reopening of this court following summer vacation.
Lord, we have taken out a supplementary affidavit.
File it on that. Not taken.
May I file that one?
Not now.
Lord, affidavit of service be kept on that.
Yes, affidavit of service.
My lord,
Yes,
my
call
lord,
the
we are
next.
in tribunal, my lord, perhaps.
Call the next.
One thing, my lord.
My lord, I'm for the petition. I'm for the respondent 56. I'm for the respondent 56. 111.
Give the file. None appears in support of the writ petition. Record her appearance. Let the matter be listed 2 weeks after the reopening of this court following the summer vacation. Next.
My lord, in this matter, my lord, I beg to appear on behalf of the respondent number 6, private respondent number 6, my lord. On the previous occasion, also the petitioner did not
Give
appear.
me-
My age is 93 years of age. And private respondent number 6. Right title
Has been dismissed. There is no question of any. So their tribunal application has been dismissed. There is no interim order, nothing of that kind. Then why you are bothering about it? Yes. None
Well,
appears in
showing this
support of the
applica-
writ petition. Record his appearance, appear for the respondent number such and such.
showing the pendency of
Let the writ petition be listed 2 weeks after the reopening of this court following the summer vacation.
my lord, may I submit?
However, pendency of the writ petition shall not stand in the way of proceeding in accordance with law.
I bow down to your lordship. That was my prayer, my lord. I bow down to your lordship. Showing I am for the petitioner. I am for the petitioner.
affidavit of service may be kept on record. One Mr. Samol Bhattacharya,
Just 1 minute. You are aggrieved by only the latter portion of the order.
Why?
That you are not declared as successor.
My lord, because initially we challenged the.
No, you did not have to narrate the story. Everything has been, now the High Court has set aside all those proceedings.
My lord.
Now you are the only person. Neither they are Borgadar, nor they can be claimed to be a Dakhalidar. There is no difficulty. Record of rights has been declared as non-est. Now, only question is that they say that whether you are the successor of Gulab Bala Dasi, you have not produced any document. And this is what is
What I am submitting in this.
dismissed. Now, what are the documents relating to that?
But that is the document, my lord. Certificate.
Where are the documents?
That is the document I have enclosed, my lord. Certificate of Pradhan.
No. Where are the documents of Gulab Bala Devi Dasi? Show us the documents, sir. Where from you can say that you are the successors of Gulab Bala Dasi. That's all. Simple.
Certificate given by the Panchayat Pradhan of the local Gram Panchayat that we are the legal heirs of the Gulab Bala Dasi.
Oh, how? Tell me. Sir, you may have some documents, you may have some Aadhaar card, you may have something. You may have some documents of Gulab Bala.
This is the document we have.
You can't take it out from your pocket and give it. Whether you annexed it.
No, it has not.
Then
annexed, my lord. Difficulty is this, my lord. What I am
difficulty is
submitting-
this, you have created, you
My
go and establish your title in the civil court.
My lord, what I am submitting, my lord, kindly
Go and
bear me for a
establish your
moment.
title.
My lord, when we challenged the Borgadarship of the private respondent, they did not appear. This honorable court entertained it and my lord rejected
That
this.
does not mean that your status has been accepted. Maybe
Subsequent,
there is
my
no objection which has come up. Now the state has raised an objection whether you are the successor of Gulab Bala.
But a series of proceeding in the High Court as
That
well
does
as in
not
the
mean so,
tribunal.
sir. You have to show just a point has been taken.
It is raised by the state, not by the
True.
private respondent.
Not necessary.
Because
The
we
state
are,
has to correct the record of right. The state will incorporate your name as a successor. The state has to satisfy that you are the successor. I just wanted the documents to come.
but they have not, they never raised this point earlier, okay, sir. All along we are contesting in the Honorable High Court,
Those were the different issues.
but they never raised this point, my lord, for the first time.
No, I
They
can't.
are the for the first time they are raising this point by the state, not by the private respondent.
I
Beneficiary are the private respondent, the recording.
please, that is a whole problem. The surname is Dipankar Ray,
My lord,
whereas Gulab Bala Sardar.
my lord, that was the
Again, and
title
the
was
Swami name is Bhushan
Bhushan Chandra Rai.
Chandra.
Rai.
Where is Roy? Bhushan. Bhushan Sardar.
Bhushan Chandra Rai subsequently, but he was the honorable justice of this honorable court, my lord. He was the honorable justice of this
Who?
honorable court.
What?
Bankim Chandra Rai Baba. Baba.
Who?
But Justice B.C. Rai was the son of Bhushan Chandra Rai.
He was the son of?
Son of Bhushan Chandra Rai, Justice Bankim Chandra Rai.
And what was the name?
And
What was the name of the mother?
Mother Golab Bala Dasi in the Malad, in the Bengali Malad
No,
family.
no, I know everything.
Dasi is
Then there are records available of this court containing all these names. Where is the difficulty?
by humble
When he was a
submission-
judge, he must have written what is the name of the father and what is the name of the mother. So you will get the name of the mother and the father from there. No difficulty.
Well, allow me to give a supplementary affidavit.
Mother is dependent or whatever. Everything
প্রধান তো দিয়েছে already, প্রধান দিয়েছে কিনা আছে কিছু পড়বে না সব আমার উপর ছেড়ে দিলে হয়। আছে আছে
was a judge. To file Agila Kodas, let the affidavit of service filed today be kept on record. Despite service, there is no representation on behalf of the respondents. Stop. Leave is granted to the petitioner to file supplementary affidavit within 1 week after 1 or 2 weeks after vacation.
My lord, kindly, I'm sorry, my lord, I could not show your lordship. Page 31. That was given by the Pradhan.
I am asking you, you have a very authentic document. 2 weeks? 2 weeks after the reopening of this court. List the matter recording. Call the next.
Can we see the order? For a moment.
Petitioner. Just 1 minute. Challenging an order of 16/9/2022?
Yes.
Just 1 minute.
Private respondent. State আর কি করবে?
You had already withdrawn earlier without any leave. How can you maintain it? And it was said that at your risk. Without any, then how can you re-agitate the issue? Order 23, rule 1 will come in your way.
Yes. Kindly comes to the previous order of withdrawal, that is at page 61.
Please.
What happened in this matter?
No, whatever, 61. Let us see what is the. How can this order is per se wrong? Why you did not challenge this order? Per se wrong.
In this case, what happens, my lord?
If you have prayed for a leave, then he can't segregate the prayer. It's per se wrong.
What happened initially when the petition was, I have understood what is
Then,
called. When the writ application was filed by lord during on the day with hearing, the learned advocate who was
sir, the law is standing in your way, sir. Are you not realizing?
Only the order says that having considered the submission of all sides, the applicant is permitted to withdraw this OA and liberty as paid for is granted exclusively at the risk of the applicant.
I do not know what is the liberty granted at the risk of the applicant.
Once I withdraw, I could have filed it again. That was there. But this is the order. There were some inherent defects in the original application.
No, that is what is order 23 rule 1 says. That you can withdraw if there is an inherent defect, no defect. Oh, I did not. Liberty as paid for is granted. Then he's wrong.
Look at it there. এও দিয়ে দাও একটা কপি। এও দেবে তো? এও দেবে? পাড়ার লোক রোজ আসে একবার করে।
This order has not been challenged by my learned.
No, this I am interpreting the order. He has wrongly interpreted the order.
But 20th April,
Sorry,
they have not
sorry,
challenged my learned.
this can't be. The tribunal application filed by the petitioner is dismissed at the nebulous stage solely on the ground that the earlier tribunal application being OA, what was the number? 1025 of 2022 was permitted to be withdrawn at the risk of the petitioner herein. Obviously, that the members of the tribunal was of the view that the moment the earlier tribunal application based on the self-same cause of action and self-same release are permitted to be withdrawn without any liberty granted to the petitioner to institute a fresh proceedings in respect of the subject matter of the said application, comma, it is barred under order 23 rule 1 within bracket 3 of the codicil procedure. At the first blast, we were of the opinion that the law as applied therein does not invite any interference. But our attention is drawn to the order, which page earlier?
On page 61.
On 28th.
To order dated 28/4/2022, passed in OA 1025 of 2022. Wherefrom it appears that the perception of the members of the tribunal appears to be contrary thereto and cannot be supported at all. The said tribunal application being OA 1025 or 2022 was sought to be withdrawn as it contained an inherent defects with liberty to take proper steps in accordance with law to stop. The moment the aforesaid prayer was made, the respondent did not raise any objection. And thereafter, the tribunal proceeded to permit the writ petitioner to withdraw the said writ petition in the following, quote from here to here. Next part. Upon reading of the aforesaid of the observations, it appears that the tribunal has segregated certain portions therefrom and proceeded on the basis that the permission to withdraw was granted at the risk of the petitioner without any further relief. The quoted portion of the order would indicate that the petitioner was permitted to withdraw the said tribunal application, and a liberty as prayed for was also granted exclusively at the risk of the petitioner. The moment the liberty is granted, such a liberty must be understood on the basis of the prayer / submissions made before the tribunal, which in no terms would indicate that such withdrawal was sought, together with the leave to take an appropriate steps before the appropriate forum in accordance with law. If the petitioner has filed the further the tribunal application before the tribunal, treating it as an appropriate forum, it is an ardent duty of the tribunal to consider the said case on merit and should not have ventured to dismiss the application at the threshold. Stop. Furthermore, the moment the prayer for withdrawal of the proceeding is made, together with the leave / liberty to be granted to pursue the remedy on the pursue the remedy in respect of the subject matter of dispute, subject dispute, the tribunal cannot of its own segregate such prayer by granting a leave to withdraw and refusing the liberty to institute a fresh suit. The prayer was composite, and the only power vested upon the tribunal is either to grant the prayer as a whole or to refuse such prayer. It is not permissible to to divide the composite prayer and grant one of it and refuses the other. Anyhow, we do not find any such situation in view of the language used in the said order, which in our opinion is explicit to the extent that the liberty was also granted, but it was unnecessary to put the further expressions within bracket, within quotes, at his own risk, without any further relief. Now, at his own risk, at his own risk, at the risk of the applicant, at the risk of them, within quotes, at the risk of the applicant. The impugned order has wrongly quoted it, at the risk of the applicant, full stop. The order impugned, therefore is not sustainable. The same is hereby caused and set aside. The matter is remitted to the tribunal to decide the same on merit.
Within certain period.
Sir, you go file your affidavits. How can we direct? It's at the nebulous stage.
Date, my lord, is 1 year, 1 date. Is 1 year, my lord. No,
Anyhow.
my lord.
Next.
My lord, this is my application, my lord.
One humble submission, madam. One humble submission. No, not regarding the dates. Nothing regarding dates. Or the concept of Order 23, Rule 1 made myself clear today. Today it was clear, absolutely. While drafting
Yes.
also I could not enlighten so much.
Well, this is my application. This matter was heard on 21st of September 2022. And next date was fixed on 10th of August 2023. My lord, for early hearing, my lord, my prayer is for early.
Which tribunal?
My lord,
Land Reforms Tribunal. So now August.
Yes. Well, after 10 months of.
This is the instant writ petition has been taken out. Primarily on the
Affidavit service.
on the score that the tribunal has fixed the matter for hearing after a gap of 10 months. The matter was lastly taken up on 21st September 2022. And the directions were passed upon the parties to exchange affidavits. And the next date was the date is fixed on 10th August 2023. Affidavits have been exchanged?
No, my lord. No affidavit filed till today.
Why you are not doing it, sir? Sorry, we are fixing a time here. If the dates are fixed after such a long time, it would frustrate the object and purpose behind the establishment of a tribunal for disposal, for securing the speedy disposal of the matter concerning the specified act. It is not expected that the tribunal would fix such a long date and without fixing a time within which the affidavits are to be filed by the respective parties, start করেছি কিভাবে? By the respective parties, এটা sentence complete হয়েছে। আবার পড়ো তো। Such a long date without fixing a time within which by the respective parties. We inquired from the learned advocate appearing for the state respondent whether any affidavits have been filed, comma, he showed his inability to disclose the fact in absence of any instruction from the concerned officer. However, the learned advocate for the petitioner submits that that his client has not been served with a copy of the affidavit in opposition as on date. Believing the statement made on behalf of the petitioner, we feel that the justice should be served if the exchange of affidavits are directed to be completed within a time frame. We therefore direct the respondent to file the affidavit in opposition to the tribunal application within today is May, within 4 weeks from date. Replies, if any, shall be filed by the petitioner within 2 weeks therefrom. Since the matter has already been fixed on 10th August 2023, we do not intend to prepone the said date. With the profound hope, with the fond hope, with the hope that the tribunal would take up the said matter and an endeavor shall be shown to dispose of the same within 3 months therefrom, in accordance with law.
Much obliged, my lord.
With these directions, the writ petition is disposed of.
Much obliged.
Communicate this order to your counterpart in the tribunal. Let's call the next.
Item 16, my lord, I am for the petitioners. Petitioners are not want to interested. This is the letter, man. I am praying.
You are the advocate on record.
Mr. Santima Bhattacharya received the instruction.
He is the advocate on record.
We are from the same chamber. So. Mr. Santima Bhattacharya is advocate on record, my lord. I am junior to Mr. Santima Bhattacharya. Santima Bhattacharya received the instruction, my lord.
Where is he?
He is not. And I am a chamber junior, my lord.
So what?
Then, my lord, make it not today.
File to the. The learned advocate on record of the petitioner submits on instruction that his client does not intend to proceed with his client's his clients do not intend to proceed with the instant writ petition. Stop. A written instruction received by him from his clients is filed today, which shall be kept on record. In view of the above, the writ petition is dismissed for non-prosecution. It are on record enough.
Mm. 117, my lord, I am for the respondent number 3. fixation of fair rent matter has been finally adjudicated by the rent controller. Rent has been assessed, that has been challenged before the tribunal. On last Friday, they not appear before lordships.
देखिए advocate
Affidavits are
advocate देखो।
eighteenth November 2022 is the order.
Relating to which property?
This is 4 Ganesh Chandra Avenue.
What was the order of the rent controller?
Rent control order is dated 24th August 2022.
What was that order?
May I hand it over? This?
No. Have you not annexed?
Yes. No, this is, I am for the respondent.
Oh.
Respondent 3, I am the landlord.
Yes, none appears in support. Matter, what has been directed?
What it is, they have prayed for stay of operation of the order. My lord, actually what it happens in view of East India Hotel, your
None
lordship.
appears in support of the writ petition. Record his appearance. Let the writ petition be listed 2 weeks after the reopening of this court following the summer vacation. However, the pendency of the writ petitioners shall not stand in the way of proceeding with the matter in accordance with. Yes. Yes. I have seen that.
Oh.
Yes, which matter? প্রথমটা কোনটা ডেকেছো? 7.
My lord, 7, 9 and 10, my lord, are covered by your lordship's earlier order. My lord, items 11 to my lord 47. My lord, are really, my lord, the new matter.
New matters. So 7, 8, 9, 10.
My lord, those are, my lord, old. Those are old matters, my lord, they can.
So this is already covered.
My lord,
No
11,
difficulty.
my lord,
What
items-
about 11?
My lord, 11 to 47, my lord, as per, my lord, your lordship's direction, my lord, the chart which was to come last night came at 1:35 PM today. My lord, and I'm told, my lord, Mr. And my lord, I'm told, my lord, there has been a personal bereavement, my lord, concerning, my lord, Mr. Shanal. So, my lord, is junior.
I didn't know.
Just,
Yes.
yes.
Sanal Junior is here, but
Yes.
Sanal, he has some personal difficulty with this.
Someone close to him, my lord,
He expired.
so he's, my lord,
Left
gone, my
the-
lord. I have prepared a chart.
Even
But you ought to have
I have
at
prepared.
135.
I have
If one has to peruse it.
No,
একটা
Give,
পঁচিশে
give.
দিয়েছেন সেটাই বলছি আর কি। আমি মানে He's not so well, he finally PTR, but
বাকিগুলো তো হ্যাঁ দাও দেখি।
no. Lordship, I am in 7 matters. Then 33, 36, 49.
Sanchita
50,
Bhaumik matter
51,
is 11.
53.
Who is appearing?
Sanchita Bhaumik 12.
You ought to have indicated. Anyhow, this is item number 12. What? 11, Sanchita Bhaumik?
No, my lord. Item 12, item 11 is Mithun Sadhukan.
Oh, anyhow, we are just this, we are taking
Oh.
this. This is item number 12. Why is this challenge?
Only why these challenge matters will be before your lordship, my lord.
No.
600.
May May I assist your lordship to, if I could? May I,
So
lordship, may I?
And someone Basanti.
when we talk about in a constitution the gender equality,
15C.
then why you are putting something which is a
My-
gender bias?
My-
Everybody is equal in eye of law.
May,
Why?
By the state government itself has been stated, female teachers are given less.
no,
That's true.
No.
That is what is a privilege that is
Lordship,
given. But the way he projected as if
Lordship, I am appearing in 7 matters, lordship, today, which are appearing where 10C, the virus of 10C has not been challenged.
then why it has come to us?
However, lordship, when these matters were placed before the landed single.
So you
bench,
just to tell us
Lordship.
where the 10C is not a subject matter of challenge. We will not hear because our bench is
No,
not
yes, my
constituted
lord,
to hear
there
it.
are 2
So
problems.
we will segregate those and says that since the 10C virus has not been challenged, let this matter be detached from us and
Now, the
and
problem,
to be
This
listed
matter have
before the
been
respective
released.
bench.
This matter have been released by the learned single bench.
So it
on
will go
this
to
ground
it will
that
go
it is
to the chief
touching
justice.
10C
It is
because
it will go to the chief justice for taking an
it is
administrative
connected,
decision.
Lordship, in the
Not
sense,
connected,
Lordship.
sir. We will not. Our bench is constituted only for the purpose of determining the vires of section 10C.
Pursuant to
We
Supreme
do
Court.
not have a regular determination in this regard.
Assigned to you, Lordship.
And therefore it is an assigned matters. If we find that the virus is not there, then the division bench cannot decide the matter on merit. Even where the virus is challenged, matter has been assigned, we will only answer the reference, we will not dispose of the writ petition.
Yes.
We will simply answer the reference and will remit the matter to the respective bench to decide on merit.
Now, since it was
That is a
pending
law.
to Your Lordship, and that notification was shown to the learned
So
single
you
judge
just
considering that.
thank you for inviting our attention.
Yes, my
Please
lord.
tell us which are those matters. We will
My matter, sir,
detach it. We'll
my-
detach it.
These are in the list. Single bench, that is,
But we'll have to say that this bench, this matter cannot
it
come
has to be
us.
assigned, Lordship.
Assignment,
otherwise-
sir, a writ petition where the virus has not been challenged, the writ petition is to be heard by a single bench. So it can be assigned to any other single bench.
It has to be further assigned.
But there is no challenge to that.
Yes.
No, that is your matter. We will see to it. We are talking about his matter.
In my matter, Lordship, it has not been challenged.
Then
It's
tell us which are those matters.
item number, Lordship, these are item number 33, 36, 49.
Just
50,
1 minute. 33,
36,
36.
49, 50,
Hey, file guno 39.
36.
49, 50,
Just 1 minute. 49, 50.
51.
Why those are FMET? Oh, sorry.
These are W.
Is my mistake. Sorry. Can you repeat it?
Yes, my 33,
And that has been emerged from the order of the Honorable Single Judge in Supriya Mukhopadhyay's case.
Where is the division bench judgment
My lord, if your lordship kindly take the
which
brief of,
went to the Supreme Court?
my lord, if your lordship kindly sees the my brief, that is there, item number 20.
It is division bench judgment is not here.
It is, in my case, all annexed.
देखिए 22 number.
और चीता राय so चीता राय I believe.
Which page?
Page 114. Prior to single bench order is 101.
Single bench order is at page 98.
I believe at P7. It is cost title Supriya Mukhopadhyay.
Page
101, I believe.
No, the Devabroto this matter.
That in cost title Devabroto, similar petition also are there.
Oh, he is also one of them.
Now, appeal bench.
Yes, just 1 minute.
Yes, appeal bench decision 114.
Consider all the matters. Last challenges the virus of the amendment notification.
Page 98 is another matter.
Yes.
Then she was challenged. It is mentioned in the ordership of the Honorable Single Judge Malisi Saraf. Thereafter 101. Similar set of petitioners. দেওয়া উচিত না তা নয় বেন্ডিং This is Bhattacharya's single bench judgment is 101, 104 the Honorable Division Bench judgment. With all the MAC numbers connected there. You'll see quoted. Either issued order, there are stay of operation of subject of transfer order. There hail the newly inserted.
Just 1 minute.
105. 115.
So single bench has stayed the order of transfer. That order was stayed by the division bench. And against that, the special petition was filed.
Yes. Now
the special petition, the Supreme Court did not interfere.
Yes.
Simply says that all such matters, legal issues, has to be heard. So it is in connection with the virus. It does not talk about anything else.
Yes.
So I think your case has to be segregated. Now, come. Record these orders in item number 33, 36, 49, 50, 51, 52, 53. All these matters have been assigned to us on a premise that the virus of the amended provisions under section 10 within bracket small capital C of the West Bengal School Service Commission Act 2017 are the subject matter of challenge therein. The order of the single bench would evince that since the applicability of the provisions contained in section 10C of the said act is intricately related thereto, and therefore the moment moment all the matters concerning the legality and the validity of the aforesaid statutory provision has been assigned to a bench, comma, such matters should also be released and to be taken up along with the other matters. Our attention is drawn to the judgment of the apex court in relation to apex court concerning several special petitions, wherein the apex court without interfering with the interlocutory order passed by the division bench express its opinion that in order to bring quitus to such legal issue, involved in those matters, it is desirable that a division bench should hear out the said matter on a on a priority basis. And all other matters concerning this, the said legal issue should also be clubbed together to be decided at one go. We further notice that the state respondent took the stand that no further transfer of those petitioners shall be made till the matter is finally decided. On the basis thereof, first off, on the basis thereof, those petitioners were permitted to join on terms and conditions indicated in the impugned order within a period of 3 weeks from that date. It is revealed from the order of the apex court that all matters where the virus of section 10C of the act is challenged, those are to be clubbed together and decided by a division bench constituted in this regard. It cannot be perceived that all matters where the challenge to the legality and or the validity of the aforesaid provisions is not an issue, though may have remotest connection therewith, cannot be clubbed together with the other matters. as the order of reference is categorical, and the moment the special bench decides the reference, the matter has to go to the respective bench having determination to decide the same on merit. Since in these matters, the virus of the aforesaid provision is not an issue, we find that it was not necessary to club the aforesaid matters with the bunch of the other matters where the virus of the said provision is a subject matter. Full stop. The aforesaid matter are therefore detached from the bunch of the cases assigned to this bench, and be placed before the Honorable Chief Justice for taking an appropriate decision in the administrative side.
Grateful, man. Because in my case, the only question is that applicability of 10C, whether it should be.
I have said remotely
yes, ma'am.
May have some, but that does not mean that
Yes,
it has to be. And so long the provision remains, unless struck off,
that goes nothing.
you know the law.
That's grateful, man.
Yes. We in fact wanted to hear out all these bunch of matters, but look at everybody has a problem.
Tomorrow, my lord, be kindly. Tomorrow or day after tomorrow, my lord.
For what?
Only to the extent of limited.
I can fix the whole day, I can invest, ensure that the councils will not argue more than 5 minutes. Ensure, everybody,
Cannot be done.
that you will not argue more than 5 minutes. There are 40 arguing councils, we will not permit them to argue for all time to come. If you ensure 5 minutes, we can.
This is the matter, Lordship. I can say that 5 minutes cannot be.
Tomorrow, very easy. And then you'll have to, I think, control or tackle the other members of the bar. Ensure that no blame, no mentioning would be done by any member of the bar. If you can ensure, no problem. We can hear from today itself.
Fix the matter, my lord,
We are fixing the matter. We propose on a Saturday so that from morning till evening,
Agreeable.
whole day, one can invest.
No problem.
But you do it
fully.
I was suggesting I can do it on 10th. 10th is a Saturday. I can do it.
Of June.
I can do it on 17th. I don't mind. Any day.
And Lordship, they are not taking any steps, Lordship.
Yesterday, my lord.
I have recorded the order of the Supreme Court, sir.
Yesterday we had my lord, subject to your.
17th.
My lord,
17th.
Your lordship, my lord, subject to your lordship's approval. Yesterday we agreed on the 24th, my lord. We can finish it off, my lord, on that day, 24th.
On 24th, will you complete?
My lord, I won't
In
take
one
more
day
than.
cannot. To one day it cannot be because the rule has been challenged there. Let it be on 24th first time. Let us proceed to the step. And your lordship hard in the year 2021. Your lordship last occasion hard these matters.
Can we fix it on both the days, 24th and 25th, both continuous?
Sunday, no.
Both Saturday and Sunday. No, I tell you one reason. I can fix it in a weekdays. I don't mind. But the difficulty is one council will say he is engaged in another court.
My lord,
Do not
24th,
hear.
25th, no
I do
problem.
not want that. I want the continuity thereof.
My lord, I have no problem, my lord.
We
24th.
have no problem. Let it.
Lordship,
Well, only one indulgence before your lordship regarding recommendation already been done. In the meantime, no coercive step in respect of other petition.
they have not taken it.
Now, why I fix all those matters? Now he intervened. That's why we passed the order. Now why we say is, there is, as the Advocate General on the other day, he said, that there is already a policy which has also come.
Yes, that policy is
Now we have.
Now he says the policy is on the basis of a suggestion or a recommendation by a bench.
not
Only on the basis of
exactly,
observation.
not exactly.
You have to extend only observation, that too.
I was summoned.
That policy decision,
No,
sir, I have.
Now somebody says that even in departure from a policy decisions, the transfers have been made.
Yes.
So we definitely say that we will take up those matters. And if we find that this is in violation of a policy decision,
Yes.
we will definitely think of doing something.
Lordship,
We
in
have
these
also
matters,
challenged-
Lordship, in
And
these
you have
matters,
seen the Supreme Court, after noticing that the virus is challenged, yet observed that you go and join. If the Supreme Court has not stayed,
All right.
now the High Court can tell us.
Yes, that can be subject to,
no,
subject to the variation of the appointment at the point of.
I do not know if the Supreme Court has said mere challenging a virus will not stand in the way, you go and join.
We shall go to the root of this.
So at this stage, one has to, if this section 10C is struck out,
everything goes.
then everything will go, everything has to be reverted back.
Yes. Now, Lordship, another thing, apart from that. Now, Lordship, what has happened? They have stopped the applicability of 10A and 10B. They say they are not going to start that, allow that. Earlier, there was
10A is a teacher centric.
teacher centric.
It is not an administrative centric. It is a
Teacher-
teacher centric.
10B
Because
also.
if the teachers, they agree mutually,
Optional.
then in that event, it is there. This is what their action is there. They can't activate the
Yes.
process.
Now, there was no administrative transfer power that was inserted by 10C. Now, Lordship, what has happened now? There was some observations after this Utshosri portal on the basis of 10B started. There was some disproportionality which was observed in various schools. The schools were vacant, schools where students were sitting idle, teachers were not there for various subjects. Because Lordship knows
And
there
the
are
position would have been converse situation may also come where the students,
opposite situation.
yes, that
Now-
is a converse situation where the students
Yes.
are no more.
Then the
Teachers are
Now,
there. Then
Lordship,
what
there
to
are
do?
two things, Lordship. The central government has come up with this new education policy, which says there will be merger of the schools where the students will not be found. Suppose so many corporation schools have been closed down. Then what will be
But
happening?
the difficulty is, suppose at that one point of time, just hypothetical, I do
Yes,
not
my lord. Yes, my lord.
It is out just an exchange
Yes,
of ideas,
yes, ma'am.
just to understand.
Yes, my lord.
Do not take it my firm view or something. It's just an exchange of
Yes,
ideas, just to understand the thing. It so quite happened, I do not know, because I also take the education matters when I was sitting singly for a pretty long time.
Vote number 2.
I noticed in many of the matters where when the school, that's it, their obligation under the constitution to set up,
Yes.
at least at the primary level, they have to do it. When the school was set up, there was a sizable number of the pupils or the candidates, the students. So there were 60 or 70 students. On the basis of a pupil teacher ratio, the sanction strength was given. By a passage of time, maybe for various social reasons, maybe various other reasons, the number of the students gradually came down.
Yes.
And it so happened that it came down to 10. Whereas at one point of time, it was 100. So considering that, there were say around 4 or 5 sanction posts which was given, teachers. Now only 10 students, 5 teachers, which is something which is in excessive. Now, second obstacle that will come. You say the merger. Merger with whom? In a distant place where the another school. Look at the plight of these 10 children. If you say that the objective is that it has to be a very close to your residence, then these 10 students have to travel, say, around 5 kilometers, 10 kilometers, or 20 kilometers. I must. Merger issue, when you talk about, then I'm saying, if it is there are 2 schools in the same village, or a nearby village where the distance is hardly 500 meters or a 1 kilometer, one can understand the merger. But if it is at the distant place, do you still think that the merger is the best way?
No.
Then what to do? Do not eat up the job of the teachers. Do not. That now it has gone down, so I sanction posts withdrawn, then what would happen to those teachers? They will be without job. So just to secure the job, if they are put into a nearby place,
Yes. So that's why
where the
rationalization.
number of the teachers are less, that I think is a rational and a reasonable
Process is
view
known as
can do.
rationalization. They have termed it as rationalization. However, this policy lacks, it talks about the transfer of teachers, but it does not
No,
talk
I
about
understand where the arbitrariness is apparent on the
Scope of-
face of
that's
the
why we
report.
have
One
not
can
shown the case.
one can think there must be a uniformity. As he says that there is a policy, whatever is come, there is a uniform way of doing
Yes.
it. That's why I was just thinking, if this uniform way is diverted or digressed,
Yes.
then one can say that you are not uniform. Your action is
We have
cannot-
challenged that. On the basis of that, in our petition,
your matter we can't hear now. It has now been segregated.
there is no
What?
this can be
Item number 6 for my calculation.
That we will definitely consider. That we will consider. If that being the position, we'll definitely consider. No doubt about it.
Item number 6 for my tabulation. Transfer from Kolkata to Farakka, Murshidabad, 300 kilometers. You know, so
Farakka, Murshidabad.
this is one of the
Kolkata to South
Murshidabad.
24 Pargana. Everywhere it has happened.
that this has been transferred to Farakka. Is going to return within 3 years. No rationalization, no. Nothing has been maintained.
One teacher got
Sir,
two
Advocate General.
recommendations.
Then tell us one after another what is where it is. This. Let us start with the Sanchita Bhomik. Yes, you have challenged the virus. Now after this, you have filed. What is the ground? Who is appearing for Sanchita Bhomik? Yes. What is the grievance? From where to where? 100 kilometers. From where to where?
Namkhan. Taligan to one of the Namkhan, 100 kilometers.
Yes. Item number 12, Sanchita. Item number? তাই তো বলছি আমি জানি দরকার নেই আমি যেটা এখান থেকে yes Mr. Advocate General, the grounds which has been assigned more than 100 kilometer, she is suffering from various problems, and according to him that requires some kind of a surgical interventions, and if she has to transfer 100 kilometers away.
I have, my lord, received it at 1:35. My lord, your lordship's desire was I should get it last night so that I could at least meet the persons. My lord. That's all that I'm saying, my lord. I am helpless with this. I've marked it, my lord, 1:35 p.m.
Without hearing him.
No.
Without hearing him. He says that yes, we are correct that we said that last evening you just gave him so that he will call the officers and will take an instruction in all the matters. You gave it at 1:35. And then you expect that he is an artificial intelligence person. Everything he will understand by feeding it and then pass an interim order. Because we find, Mr. Advocate General, we find that there are certain where the human touch is required, and this can't be done in this way.
My lord, I'll look at it, my lord.
So you look at it because we can't pass any interim order, but we express our mind in those situations where we find really it's unreasonable, absolutely shocking to our conscience. Then first matter shocks to our
In my
conscience.
matter also, 120 kilometers.
It shocks to my conscience.
My lord,
Why such a, may I use the term girl, be shifted? 100 kilometers? No.
My case,
Can't be.
120 kilometers, 2 years between this. From Howrah to Bangalore.
Don't sprinkle, I think, the fuel to a devastating fire. You are sprinkling fuel. Why we are talking to Advocate General. Yes. How? Tell me. How? When? How?
my lord, tomorrow, day after, my lord, kindly keep it. Let me take.
Can we keep it tomorrow in the first half? By this time, will you be able to take all the instructions?
একদিনে হবে, কালকে তো পরশুদিন করবো।
My lord, kindly keep it day after, my lord.
Because 49 petitions.
Is the Thursday?
Thursday করবো। একদিনে সম্ভব হবে না।
अरे भाई then तो जने हो ना इटा 2 PM করে দাও my lord Thursday 2 PM
has been issued, no transfer order has been issued.
That is what he said. Please. He has said already that we have not issued any transfer order thereafter. He has said. But still, what he said yesterday was that so far as the coercive steps are concerned, it was in relation to those matters where those which were filed pre-policy. And there are certain matters which are filed post-policy.
and my lord not just that
So that's he says that this particular, the undertaking will not be extended to them. For that reason, we sat. We fixed this matter. You were there. You understood. And then you are saying all these things. We will pass an interim order if this occasion so arises. We'll pass an interim order.
Careful.
And if the occasion does not arise, we will refuse the interim order. No difficulty in both ways.
We bow down to your lordship, my lord. Let it be
So
there.
let him take. Why don't you come tomorrow at 2 PM?
my lord I'm lucky I'm before your lordship today my lord. I told your lordship yesterday when your lordship was fixing it that I may not be able to get away. Luckily my lord, court one did not say today. So my lord, kindly keep it day after. My lord, my lord, see if I, my lord, also feel injustice, my lord, has been done. I can also suggest something so your lordship may not.
That is what is expected
Yes, so,
from.
my lord, I will, my lord,
No
speak
difficulty.
to the concerned people, my lord. My lord, that's the only reason I'm saying. 10:30 though.
Even tomorrow,
Thursday. So kindly keep it Thursday 2 PM, my lord, where they won't take too much time.
tomorrow some matters are also fixed in court number 18
ঠিক আছে, Thursday to PM.
on the policy.
Thursday 2 PM? Yes.
এটা একটু বলে
And
দাও।
we are all handing over the synopsis to my advocate general.
No, we hope that in some of the matters, it appears, I do not know, I have not seen it. First matter I see.
Now,
I have-
mostly lordship, I have
Can't.
inspected
Should not
almost
be.
all the grounds. One is distance, another is complete non-application of mine.
I tell you, the distance I will consider thereafter, but there are certain, she's suffering from
Lordship,
that ailment.
Lordship, in those cases, lordship,
It's
my
not
matters
expected.
can it-
It's not.
Lordship,
Come to that first page, bottom, 4.
lordship, those matters your lordship has released.
How can one be so inhuman?
No, the policy, my lord, inhumanness, my lord, look at it.
No,
differently.
no.
No, policy provides for cases. Provides for these cases.
Then why it was not taken care of?
No, my lord, but this doesn't come under it, my lord. That's what I want to show.
If you think that only these will come, sorry, there are many things
My
which
lord,
have.
my lord, may I, my lord, make a suggestion? My lord, are my learned friends willing to proceed on the basis that there's no policy? My lord, I will argue it then immediately now. Because the latest Supreme Court says, my lord, that transfer cannot be stayed at the ad interim stage. I'll cite it. My lord, I am trying to be fair, my lord, to say, my lord, let them, my lord, point
Come.
it out. So, my lord,
Come on. Now you realize what the jolt that came from him.
Yes, we have got.
Now we fear it.
We have got.
My lord,
the
your
point.
lordship's
That
aware.
is why.
My lord, your lordship's
That
aware.
is why a few days
Your
back.
lordship is aware of that decision.
That is why a few days back I have said to him that learned advocate is now unique one in our Unique one. I have used two. That
You
what
always-
itself. Always,
No,
my lord.
I've tried to help.
Always.
Which is, my lord?
Always.
Sir, yes.
Sir, এই কপিগুলো কাকে দেবো?
The learned Advocate General showed his inability to Baki sab barring this. The matter were listed today as several writ petitioners were insisting for an interim order to be passed in their respective writ petitions. It was echoed that an undertaking given by the learned Advocate General in some of the matters, that the coercive steps shall not be taken against the respective writ petitioners should also be extended to the aforesaid writ petitioners. Full stop. However, a submission was advanced. However, the learned Advocate General communicated to this court that subsequent thereto, a policy was framed in order to bring a fairness and transparency into order of transfer, and therefore the undertaking which was given prior to the said policy cannot be ipso facto extended to these writ petitions. After hearing the aforesaid submissions, we directed these writ petitions to be listed, to be heard individually for the purpose of passing an interim order. And we directed the council of the respective writ petitioners to make a compilation and circulate and serve upon the office of the and file in the office of the learned Advocate General to enable him to take appropriate steps. It is submitted that the said compilation has been served at 1:35 p.m. today, and therefore, because of the scanty time, the proper instruction could not be secured. Considering the urgency of the matter, more particularly when it relates to a transfer of a teacher from a school to a school at the distant place, let these matters be listed on Thursday to be taken up. Thursday date to be taken up at 2 p.m. Come.
Lordship,
May I only make one
Lordship,
prayer?
may I make? Lordship, kindly take those matters up. Otherwise, Lordship will be facing the trouble. Lordship, we are
What matters?
Lordship, those matters.
More matters have been taken off.
No, Lordship, these are released by this learned single
It will
bench.
immediately go to the Honorable Chief Justice. The
Only
Honorable
the
Chief Justice
urgency
will
is there,
pass an order.
Your lordships will kindly,
Those matters, Lordship, kindly take it up, Lordship.
Which matter we will take
Those,
up?
those matters which have been.
Only the matter where 10C is the virus is challenged, we will take up. Otherwise, other matters, please give same order would be passed, it will go back.
Your lordships will
Go
also.
before the single bench and get it done.
Administrative notice also there.
Then
That we can.
That administrative notice after the assignment also there. Only 10C matters to be heard, to be tagged with kanji.
That's true. It is very clear.
Very clear.
so lordship, those
So we can't take up those matters. Sorry.
Your lordships will kindly direct the petitioners to give the compilation to the commission also.
22 যাবে।
দেখলেন ওটা
Give
22
one
22
copy
যাবে।
to them.
My lord.
Give. Today, no assurance. When you say today, we have seen.
No.
Tomorrow.
Those matters which where virus is under challenge, lordship will mention the matters before your lordship tomorrow. Some of the matters.
We'll decide it. No difficulty.
Yes.
Harish. And come, we will fix on 24th and 25th, if all agree.
Yes, we are
No
agree.
difficulty.
Yes.
You have to finish within 2 days.
2 days.
And we will try to finish within the month of June.
Grateful.
Yes, come.
And my lord, since the assurance is given by Honorable learned Advocate General,
I'll do
it
it, my lord.
will be.
Before 25th, I have no problem.
He has already
Yes.
in court number 18 also, he has for 1
We
week.
are-
I am protected.
We are
Nothing has-
sure it will be coming, my lord, a fruitful result.
Last Wednesday, he said nothing will happen. It has not happened.
Yes. He
In
said.
court number
Last Saturday, we fixed one matter. State took such a weird stand. Everything went down. Mr. Mukherjee, Topan Kumar Mukherjee.
My lord,
Hmm.
my lord, food department, I'm told.
Hmm.
Yes, come on Thursday.
Much obliged. to the-
Call.
PM হলো না?
হ্যাঁ, Thursday.
এই কাগজটা দাও। যেখানে ভাইরাস এই এটা রেখে দাও কিন্তু আলাদা করে রেখে দাও হঠাৎ করে একদম সত্যি Yes, call. Yes, call the next matter. Yes. একটা কষ্ট হবে একটা করে রাখো তারপর পরের বার থেকে তো একই জিনিস হবে Yes, who is appearing? Yes, none appears. Let this matter be listed 2 weeks after the summer vacation.
My lord, in this matter, I am appealing on behalf of the petitioner. My lord, this is for my lord early disposal of the matter before the learned tribunal. Yes. Next date has been fixed on 9th of June. my lord. No, Dr. Time.
So now it is in a close proximity of time as a motion. Why you are appearing? We appreciate after 10 months, 11 months, 12 months, the dates are fixed. How many benches functions? Only one?
Only fourth bench.
4 benches.
Number of bench are 4.
4. And all 4 are operational.
Yes.
All 4 are working.
Yes, ma'am. One judicial member, my lord, one judicial member is taking 2 benches.
No. How many benches I am asking you?
4 benches, ma'am.
4 benches. Each benches consist of 2 members.
2 member. No. One judicial member.
Sir, I am not asking you one judicial member, one administrative member, one chairperson. I do not want. I simply want 4 benches. Each bench is of 2 members. These 2 are a judicial vacancy, judicial member or an administrative member.
No, one judicial member and one administrative member.
So literally 3 benches are functioning with full complements of the members. No problem. সই করেছে 2 member.
There are 4 benches. The Honorable first bench is running with the chairman on the whole day with one administrative member. Second bench is running one judicial member, one administrative member. After the exhaustion in the second bench sits at 11. Second bench sits at 11.
Why?
There are bench functioning from all benches starts from 11 a.m.
There the working hour is from 11 or 10:30.
11.
11. So all the benches they sit at 11.
11. Second bench at 11. After completion of the list of the second bench, the judicial member of the second bench sits at the third bench. And the fourth bench.
Third bench with administrative member.
Administrative member of fourth bench.
Third bench running with the judicial member who is sitting in the second bench as well as the third bench.
Sir, let me rephrase what you want to say. That so far as the first bench is concerned, it is
chairman
and one administrative member, no problem. They are sitting full time.
Full time.
So far as the second bench is concerned, one judicial member, one administrative member.
Yes.
But so far as the third bench is concerned, no, there is nobody.
No judicial.
Nobody. Then the second bench judicial member, after completing the second bench matter, sits as a judicial member of the third bench with administrative member
Fourth bench.
of fourth bench.
Fourth bench sits at 11.
And fourth bench sits with the judicial member
Separate judicial member.
separate.
Separate judicial member. Chairman and another.
I got you. I got you. That's why I'm just thinking to correlate. Then why the first bench is not working to, this which bench? Fourth bench.
Good.
So fourth bench has a full complement. Fourth bench has a full complement.
No, the fourth bench.
He has to only spare administrative member. He has to spare his administrative member for this third bench. Correct. So he has the full composition. Why he will not dispose of his matters of fourth bench? After disposing, he can spare his member, no problem. Second bench judicial officer ওখানে যাবে or ওখান থেকে administrative member কে limited. But it is a fourth bench. Fourth bench has a full complement of members. What to do, sir? The date has arrived. You have filed so belatedly. What can be done?
No, my lord, I have filed in the month of December.
November. So, and the order was passed in June. What you were doing for so long? We have passed in many matters. We have directed the preponement. Now what we can do? Summer vacation. Immediately after reopening, the matter is fixed.
But in the at 9/6. No.
What is the purpose of this status report? You appear. What is this status report? Why not the opposition? What is the significance of status report?
Report also, my lord, we have submitted for honorable bench. My lord, this is not the by way of affidavit. They are, my lord,
So that is why, how can you rely upon that?
So that submission was made before the honorable tribunal also.
Yes.
That is not the my lord, where that the report in the form of affidavit. What is, my lord, the here my lords are accepting. That is only, my lord, their signature of the PLRO concern, authority concern, annexing the some record of rights.
Kindly fixed, my lord, for a specific time, my lord, so that the matter can be disposed of.
The writ petitioner seems to be aggrieved by an order dated 10/6/2022 passed in OA 1408 of 2022 by the West Bengal by the fourth bench West Bengal Land Reforms and Tenancy Tribunal, wherein the date for moving the motion was fixed after nearly a gap of 1 year. When the instant writ petition is taken up today, we find that the date so fixed by the tribunal is in close proximity of time, and therefore interference appears to be unwarranted at this stage. We trust and hope that the tribunal would take up the matter on the said date so fixed, that is 9/6/2023, and an endeavor shall be shown to dispose of the proceeding as expeditiously as possible, without granting unnecessary adjournments to either of the parties, unless necessitated by unforeseen and unavoidable circumstances. With these observations, writ petition is disposed of.
In this matter, I am appearing for the respondent number 5 to 9. But I am of the petitioner. Respondent number 5. Kindly see the order page 13. Okay. Title suit is.
So you have hijacked the right of,
Oh, yes.
right to begin. You argue that on his behalf. You are for?
Petitioner.
He has hijacked your right to begin.
Well,
This is not expected, sir.
sorry. The
Don't-
present petitioner.
We know we will go through the order. You have seen that we always say we'll go through the order. Yes, order is 8/7/2022 order. Yes,
Page,
13. Which order you are challenging?
paragraph 30, page 13, my lord. It appears from.
Just, you need not have to. I am faster reader than you. Status quo was in respect of what? Status quo in respect of what?
Title suit for partition.
I am asking you, status quo was in respect of what?
In
Where is the order?
Kindly see the order, my lord. Position and possession. চেক করিস না তোরা।
What was the allegation made in this temporary injunction application?
Partition suit, the directing the parties to maintain status quo. That was.
Not so simple, sir. I am asking you, sir, tell me what was where is the application for temporary injunction?
For injunction.
Status quo also with regard to position and possession.
এখন order 39 application. Defendants are trying to disturb the peaceful possession of the plaintiff over the B schedule property and to make construction on the A schedule property. This is the allegation.
This is what I really wanted to know as a civil lawyer.
That's right.
How this position has to be interpreted. This order is not correct.
My lord, this order is there. That's why, my lord, this title suit is,
Can't be.
is there.
Can't be done. Can't be done. It was a suit for simpliciter for partition amongst the co-sharers.
That's true. That's true.
And the temporary injunction was sought because some of the co-sharers were continuing to make the construction and some of the co-sharers were trying to dispossess the other co-sharer from the joint property. In the backdrop of those allegations, the status quo has to be construed.
Yes.
The word position means the position in relation to a construction at the property. The position does not relate to an entry in the record of right or relate to something else.
No,
Can't be.
yes, their allegation, my lord, they made an application before the BL and LRO
for correcting the record order.
Correct, the PLLRO will take it. The mere entry in the record of right does not wipe away the title nor can create a title.
That's
So-
mere.
So why he
record
will
of rights
dispose
is
of
not
the matter?
right of title or.
Can't be.
You must-
Can't be. We have been noticing from the several orders passed by the West Bengal Land Reforms and Tenancy Tribunal that a uniform stand, the uniform is standard in passing an order is consistently adopted by directing the government representative. Obviously, the respondents in the proceeding to submit the status report. Stop. We are informed by the appearing counsels who also frequently appears before the said tribunal that such status reports are called for, which is neither verified by an affidavit nor a copy thereof was made available to take an exception thereto.
Only piece of papers, man. They have submitted the status report.
If such course is adopted and the reliance is placed on such a status report and the disposal is secured, it not only amounts to a violation of the principle of natural justice, but also adoption of a procedure unknown in legal parlance. If the tribunal construed the status report as an exact state of affairs in relation to a dispute, there is no impediment on the part of the tribunal to direct the respondents to disclose such facts on oath by filing an affidavit, so that it would give an ample opportunity to the writ petitioner to controvert or disclose his stand thereupon. Using the status report as a document concerning the members of the bench only, without making available to the writ petitioner, is unjust enrichment upon the right accrued to the writ petitioner in an adversarial system of adjudication governed by its procedural and substantive law. In the instant case, solely on the basis of the status report, the writ petition has been disposed of. The writ petition is adjourned. The tribunal application is adjourned sine die till the disposal of the title suit. pending before the court without ascertaining whether the interim order passed in the title suit has any bearing on the issues raised in the said tribunal application. Mere passing an order of status quo does not mean that it would forestall the proceedings pending before the forum, but the status quo must be understood in the perspective of the facts pleaded in the plaint as well as an application for temporary injunction. Though the expression status quo is an expression of ambiguity, yet it is capable of being ascertained on the basis of the pleadings of the respective parties. Stop. The aforesaid title suit number 174 of 2009 was filed before the civil court for partition and separation of shares. Partition on separation of shares. It has got no nexus so far as the entry in the record of right is concerned. As such entries neither creates any title into a person nor extinguishes the same. An application for temporary injunction was taken out, alleging that the co-sharer is trying to make construction over the undivided property and also taking and also trying to dispossess the plaintiff without taking recourse to law.
It is the allegation, my lord, made by.
On the basis of the aforesaid allegations and or averments made therein, the order of status quo was passed in relation to a position, in relation to a present position and the possession of the suit property is still the disposal of the suit. The expression present position cannot be construed in relation to the entry made in the record of right, as such expressions would mean in relation to a construction alleged to have been constructed by allegedly attempted to be made in respect of the joint property. Any other interpretation would give an would render the said order to operate beyond the peripheral thereof and would be construed so wide to imbibe within itself all conceivable eventualities. Stop. We thus do not find any fetter on the part of the tribunal to hear out the application, the tribunal application, as the judgment, preliminary decree or a final decree passed in the partition suit shall not impact the decisions to be taken in the tribunal application. on merit. We therefore set aside the impugned order and direct the tribunal to fix the date for hearing of the said tribunal application, and effort should be shown to dispose of the said tribunal application within 6 months from the date of the communication of this order, after affording an opportunity of pleadings to be filed if required, and hearing to the respective parties.
May I submit one thing? Well, tribunal's order dated 8th July 2022. Not only that, my lord mentioned.
Impugned order we have set.
8th July 22.
Affidavit of service is taken.
Let's call the next.
Regarding present position, allegation. কি অসুবিধা আছে ওখানে যদি করে সবার নাম কি করেছে এটা তো ওপেন করে রেখে দিয়েছে, কেন ফাইল করে আমি তাই জানি না। কি করবো, 22 ম্যাটার ডিসমিস করে দিয়ে
Yes, none appears dismiss.
এখানে করেছে অর্ডার স্যাটিসফাইড করে
Yes, next.
The applicant, ma'am. Only available service.
Service.
This one, sorry.
Why you are challenging? You should be happy. Nowadays, everybody wants that the pond should be deleted from the record of right, so that he can go, and you are the person
Petitioner wants to say what the body.
where the pond has already been deleted. You wanted the insertion of the pond.
In the every deed, my lord, there's mention about the pond, my lord.
I understand.
I understand.
Are you doing a fishing there?
But in 5 or 6 years ago, my lord, there was fishing, my lord. Pisciculture was there, my lord. But now it become.
So why you are agreed? I do not know.
But I am agree, my lord, I want to save the water body, my lord. But
Oh.
if the fire takes place, my lord, in that locality.
True, then you are a good, Mr. They, why don't you appear? Appears to be a very fair person.
But there is some separate.
Only very small dispute. He is a co-sharer of the plot. He found that in the CS, in the RS, and in LR record of rights, the entire property has been shown as Bastu land.
Yes, ma'am. Yes, ma'am.
Whereas he say that it is not totally Bastu, it is partly pond, partly Bastu. So please correct the record of rights. Look at the fairness. Nowadays, everybody wants to get away with the pond.
But there is old deed and current deed. Every deed, my lord, there is a civil portion, there is pond, my lord.
So you should consider it, and you should really compliment him that he is such a fair person who has come. CS record, RS record, subject. Despite service, there is no representation on behalf of the state respondents. Let the affidavit service filed today be kept on record. Considering the nature of the impugned order, we feel that the presence of the state respondents is necessary. Mr. Chandicharan De, the learned additional government pleader, who is present in court, is requested to appear in the instant matter. The learned advocate for the petitioner shall serve the copy of the writ petition upon him in course of this day. Can you?
Yes, my lord. Yes, my lord, I can.
In course of this day. Who will regularize your legal remembrance, sir? ILR, your appointment? The legal remembrancer is directed to regularize the appointment of Mr. Day in the instant matter. Let this matter be listed immediately after reopening 5th of June 2013 under the heading motion in the supplement. 7th June. Otherwise, 5th is a monthly list. You will go down. 7th June in the supplementary list under the heading listed motion. Stop. In the meantime, Mr. Day shall take an appropriate instruction from the concerned department.
Which is good. Appreciate it. Long back ago.
In this matter, I am appearing on.
On the basis of the deed.
Details upon. Generally, देखा जाए ना.
My lord, this is for my lord early disposal of the matter, my lord. Matter was taken up for hearing on 10th of November 2022, and the date has been fixed on 27th of November 2023. After lapse of 1 year.
Status report.
though the writ petition is filed assailing the order dated 10/11/2022 filed by the, passed by the second bench, West Bengal Land Reforms and Tenancy Tribunal in OA 3101 of 2022. But at the time of moving the instant writ petition, the learned advocate submits that the direction may be passed to secure the early disposal of the said tribunal application. It appears that the said tribunal application was moved on 10/11/2022. Sir, we will not pass. We will not pass the order. You prayed for an accommodation to submit the affidavit of service by the next date. You did not serve the copy of this application. And then on the very second day, you are coming for a expeditious disposal.
No, I have served one.
No, look at the order of 10/11.
Copy was, my lord.
Prays for an accommodation to submit the affidavit of service by the next date fixed.
No, my lord, copy was, my lord, submitted, my lord. Kindly see, my lord.
Sorry, you did not. Why you prayed for time? Why you prayed for time?
At that time, my lord, it was not ready, my lord.
No, then
My lord, I
first
have
day.
duly submitted, my lord. Kindly
When the tribunal application was filed,
tribunal application was filed, my lord. On
yeah,
10/11.
10/11.
no, 10/11, no, my lord.
Will you? The choice is yours. If you move it, we will dispose of the writ petition.
So, my lord, kindly see, my lord, I have submitted the evidence.
You are moving the writ petition.
My lord, I have submitted, my lord, duly submitted the evidence.
Are you moving a writ petition? Tell us.
না বইটাই তো এবিলিটি সার্ভিসটা তো আমি জমা দিয়েছি পরের দিন বই ঠিকই ওই ডেটই দিয়েছি কোনো কোথায় সাবমিট হয়ে গেছে it was duly submitted affidavit of service before the learned tribunal.
I am again asking you, are you moving a writ petition? Then you move. Yes.
Kindly pass necessary order. Kindly pass necessary order.
Yes.
My lord, I am withdrawing the my lord. I do not want to proceed with the matter, my lord.
Oh, you said pass the necessary order, so I was going to dictate. What? What do you want?
I do not want to proceed with the matter. Because, my lord, since my lord, the order is defective, my lord, I have duly submitted. I have not checked it.
Let us dictate.
No, no, my lord.
It is for the bar, I will dictate.
No, no, my lord, I am not.
A affidavit of service. Advocate on submits on instruction not to proceed, to withdraw the same, permitted. ও একটু লিবার্টি চাই, লিবার্টিটা কি? What do you think? To appear personally before direct করে after vacation. পারফেক্ট, এখানে তো ঠিকই বলেছি। Dismissed, none appears. You are appearing. Record his appearance. None appears in support of the writ petition. Record his appearance. Dismissed for default.
My lord, in respect of 126, Mr. Mrinal Kanti Ghosh is appearing for the petitioner, my lord. My lord, praying for just not today, my lord. He's engaged. My lord, he has just now been engaged.
Who is the advocate in record?
Mrinal Kanti Ghosh, my lord.
He is the advocate in record.
Yes, ma'am.
After vacation. An accommodation is sought on behalf of the petitioner. Let this matter be listed after the reopening of this court following the summer vacation. বলো ওকে পরের ম্যাটারের ফাইলটা আগে থেকে রেডি করে রাখবে। এখন 6-1 হয়ে গেছে এখন এই dismiss, none appears. যখন একবার অ্যাফিডেভিটস এর ডিরেকশন হয়ে গেছে তখন তো মোশনের আসার কি দরকার? তাই তো এটাতে একটু বলে দেওয়া উচিত। ইয়েস, আফটার ভ্যাকেশন। এইটা ঠিক নয়, সেকশন 5 এ উড়িয়ে দিল। After vacation. None appears. Let this matter be listed after vacation, after summer vacation. What is going on এখন? I do not know in the tribunal. In this matter, you are appearing. One of the party died, substitution is to be taken out, and the matter is fixed after 1 year for substitution. And it is unacceptable. Why don't you take steps? Why don't you take, the further inquiry so far as the appointment is concerned? And why you continue extending the time? I think you just fix a 6 months time. Why you extend the time? After vacation, it's a good case. We have to. Then 1 year. Where is the petitioner? Hey, after vacation, এটা একসঙ্গে সব রেখে দিও। Jekota after vacation Bochi, all will be listed immediately on the reopening day, one after another. At a common order একটা দিয়ে দেবো। Sure. গেছে ভালো জানি After vacation. इसको दादा से
I am waiting for the response number 5678, private response.
who's for the petitioner?
I'm also,
Who's for the petitioner?
Body is appearing.
nobody is appearing for that.
Do you know him? You don't know him?